Mr. Nelson, you may close for the defense.
May it please the court, counsel, Mr. Chauvin, members of the jury. I want to take this opportunity first to thank each and every one of you for your service, your diligence, and your attention to this matter. We all recognize the disruption that jury service places on your personal and professional lives, especially in a case of this magnitude and duration. And so on behalf of Mr. Chauvin, I want to thank each and every one of you for your attention and service to this jury. I'm going to apologize if I get a little long-winded, because I get one bite at the apple here. The state has an opportunity to rebut my statement after this. There's so very much we need to cover. There's so very much we need to talk about, and it is all important. Before I begin my review of the evidence in this case, I would like to address two very crucial points of law, and they were touched on by the state. The presumption of innocence and what proof beyond a reasonable doubt means. The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges, and this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence. Proof beyond a reasonable doubt. Here's the definition that the judge just read you. Proof beyond a reasonable doubt is such proof as ordinary prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes three standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. And the way we lawyers sometimes illustrate what these three standards mean is through the scales of justice, right? The scales of justice equally balanced. When you apply the standard of the preponderance of the evidence, it's also called the scintilla of the evidence. A single grain of sand tips the scales in the favor of one party or the other. And this burden of proof is used in many civil cases. If the state wants to take away your driver's license, for an example, that is the burden of proof that the state has in that type of a case. They have to just ever so slightly convince the finder of fact that their evidence supports their action. The next standard is clear and convincing evidence. I mean, that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder of fact, that the action is correct. This is the standard of proof that is used if the state wants to take away your children. Clear and convincing evidence. It tips the scales more in the favor of one party over the other. The highest standard in this country is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Essentially, what the state has to convince you is that the evidence in this case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Capricious, fanciful. Capricious doubt, capricious means unpredictable. Fanciful, space aliens flew in, inhabited the body of Derek Chauvin, and caused this death. That's fanciful. Beyond the reasonable doubt. It is the highest standard in the law. Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious. So these two standards, the presumption of innocence and proof beyond a reasonable doubt, work in concert with each other. You start with the proposition that Mr. Chauvin is innocent of these charges. The state has to advance substantial evidence to convince you that the only doubts that are remaining are unreasonable doubts. As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced is unreasonable. That's what this standard is all about. I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen, and lawyers, and I'm going to do it too, right? We pick and choose those things that help us make our case and help us argue our case. That's our job as lawyers, is to point out words and phrases within the instructions that make the difference in the case, and to take that evidence and present it to you in such a way that it supports our proposition. That's what we do. That's why you are instructed that if your memories of the evidence is different, that if the judge's law is what applies. But take the time to carefully read the entire instructions. Throughout the course of this trial, you've seen us do this, right? Little snippets. A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So take the time and conduct an honest assessment of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole. I've told you that lawyers like to present evidence that favors them, right? But we have to be intellectually honest about the evidence. We have to present it in an honest and intellectually cohesive and coherent manner. And I have to address something that I think is important. And I think it is a prime example of what I am asking you and what is your obligation to do, to look at the evidence in light of all of the other pieces of evidence, right? So you heard during the testimony of Dr. Fowler that one of the things that he considered is the possibility that carbon monoxide was present and could have contributed to an environment that created an oxygen deprivation. You heard that testimony. In rebuttal to that testimony, the state brought Dr. Tobin back in, and he told you, we can completely disregard that. We know as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level? But that's not intellectually honest. It doesn't stack up against the rest of the evidence because of what we know, right? We heard the testimony of Seth Bravender and Derek Smith, the paramedics. We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts. They introduced oxygen, an oxygen supply. They're manually breathing for him. They're reoxygenating his blood. So when you look at that piece of evidence, when you look at a piece of evidence like that, you have to compare it against all of the other evidence. Because you can't come in and say, George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level, right? His blood is oxygenated. Then stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare it. That is what you as jurors are obligated to do and what I am asking you to do. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt. Mr. Chauvin has been charged, as the state indicated, with these 3 charges, and the judge has instructed you. Count 1 is second-degree murder while committing a felony. It's also called the felony murder rule in Minnesota. Kind of the textbook example is I run into a liquor store, I pull a gun, I'm intending to rob the liquor store. My gun goes off, I shoot and kill the teller. I didn't intend to go in and murder that person, but the death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that is eminently dangerous. Right? You've seen the instructions, you've heard them. And manslaughter in the 2nd degree. Again, the law has all of the words, it defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client, I try to explain what the elements are, and this is the analogy that I use. I say that a criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients, you can make chocolate chip cookies. But if you're missing any one single ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say, we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt. They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict. And you saw the spreadsheet that the state put up, right? The elements are a little different in each of these cases. And some of these elements will take less of your consideration. You will have to look at the evidence, and you will have to, for example, determine is Cup Foods in the city of Minneapolis, is Minneapolis in the county of Hennepin, is Hennepin County in the state of Minnesota? Did this happen on May 25th, 2020? Right? It's going to take less of your consideration, but nevertheless, you have to do that. You have to go through that process. Two of the elements that I want to focus on during the course of my discussion here today, two of these elements are common throughout, or two of these issues are common and apply to all three counts. And so I want to focus my remarks today on those two issues. The first, were Mr. Chauvin's actions an authorized use of force by a peace officer, right? Because in the instructions, it specifically tells you no crime is committed if it was an authorized use of force. Period. End of discussion. The second is an element that is and does appear in all three counts. That is the cause of death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, no crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations. The defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. So, if you remember from my opening statements and how I talked about reason and common sense, right? The reasonable police officer standard. I want to just briefly add one thing here, is the standard is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these circumstances. The standard is what were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done? You have heard from numerous experts, police use of force experts, the training department from the Minneapolis Police Department. You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force. But one of the things that one of the things that all of these police officers effectively agreed to is that when you look at the question of what would a reasonable police officer do, knowing the facts of the case, there are things that a police officer is entitled to take into consideration above and beyond the facts, right? Their training, the training that they receive, their experience as a police officer, the department's policies on the use of force. And all of these things kind of lead into the question of, most critically, what are the facts that were known to the police officer, the reasonable police officer, at the precise moment the force was used? So you can start at a very high level, right? What were the reasonable police officer's knowledge of the area be? Is this a high crime location? Is it a low crime area? Those are things, those are facts that a police officer would know. What are the specifics of the location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats. Officers are entitled to kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages. They can take into consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts. So kind of, again, focusing back into what facts were known at the precise moment force is used, you can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians. The reasonable police officer takes into account the safety of the person that they are arresting. They take into account, what resources do I have based upon? How close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take them because they're farther away. Calling for help, bringing help in would take longer than it would simply to take the person directly. And then you look at the direct knowledge that a reasonable police officer would have at the precise moment force was used. That includes information that they gather from dispatch, their direct observations of the scene, the subjects, and the current surroundings. They have to take into consideration whether the suspect was under the influence of a controlled substance. They can take into consideration, because again, this is a dynamic and ever-changing, just like life. Things change. It's a dynamic situation. It's fluid. They take into account their experience with the subject at the beginning, the middle, the end. A reasonable police officer tries to predict, or is at least cognizant and concerned about, future behavior based upon past behavior. But the unpredictability of humans factors into the reasonable police officer's analysis too. Because sometimes reasonable police officers take someone into custody with no problem, and suddenly they become a problem. It can change in an instant. A reasonable police officer will take into consideration his immediate surroundings. Are there bystanders? Are there civilians? A reasonable police officer will take into consideration who he is at the scene with. Are these veteran officers? Are they rookie officers? What do I know about my partners and my partner's abilities? So throughout the course of this trial, the state has focused your attention on 9 minutes and 29 seconds. The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with, what did the officers, or what would a reasonable officer know at the time of dispatch? Well, these are records that are kept. They've been introduced. You can look at them. This is Exhibit 151. This is the computer-aided dispatch report. You heard the testimony of Jenna Scurry, the 911 dispatcher. This is information that they are passing out to the officers. You will see that the initial information that a police officer has in his squad car looking at his computer or hearing over the radio was that on May 25th, 2020, at 20:02:13, so that's 8:02:13, a business, Cup Foods, who police officers have the obligation to respond to these calls, whether it be from a person or a business, but a citizen of the state of Minnesota, Minneapolis, runs a business, and they called for assistance. And they told the officers, the reporting party, there is a male who provided a counterfeit bill to the business. He's 6 feet tall or higher. He's sitting on top of a blue Mercedes ML320 SUV. The license plates also appears this subject is under the influence. So the analysis of what a reasonable police officer would know in this circumstance is that a business is requesting its help. The suspect is still there. He's large, and he's possibly under the influence of alcohol or something else. So the analysis begins at 8:02 and 13 seconds. You may recall the testimony of Jenna Scurry as well, and it's not reflected in this exhibit pretty well, but in the evidence, exhibit number 10, you can hear the audio recording of the dispatch, Jenna Scurry to the officers. Jenna Scurry informed you that initially Officer Chauvin was assigned to this call on a Code 3 Priority 1 basis. It's Code 3, get their lights and sirens, get there fast, right? It's Priority 1 because the suspect is still on scene. So per the Minneapolis Police Department policy, get there fast, the person is on scene, right? That's what she testified. And then very quickly after that, that occurred at 8:04 and 28 seconds. Then what you see is, or what she told you, was that the sector car 320, that's the car that patrols this part of the city, said, hey, we can take this call, and Officer Chauvin and Officer Tao were canceled from the call. Right? So they were canceled from the call, and sector car 320, Officers King and Lane took it, and that occurred at 8:05 and 11 seconds. When Officer King and Lane took it over, you can hear, again, you can go back and you can listen to that audio of that dispatch, and you can hear them talking to each other. Officers King and Lane arrive at the Cup Foods at 8:08 and 20 seconds. So now we see police officers are responding. They're on scene at 8:08. Both Jenna Scurry and Peter Chang described that during the course of the interaction between the initial interaction between Officers King and Lane and Mr. Floyd, through dispatch they heard what sounded like the sounds of a struggle. Jenna Scurry described she's trained to listen. She heard these sounds of a struggle, and she aired out on her own, other officers need to respond, code 3, to assist Officers King and Lane, right? So a reasonable police officer, he's going emergent to a scene, he gets canceled from the scene, he's now being told that other officers need assistance, and step it up, get there fast. So you can see again, based on the records, that at 8:10:08, 20:10:08, backed up 320 with 330, right? So now 330 is Officer Chauvin and Tao. They're backing up Officer King and Lane. And you can see Peter Chang respond at 8:10 and 21 seconds. You hear 320 taking one out. So that means they're removing someone from the vehicle at 8:11:02. The scene is ultimately C4, code 4, all clear at 20:12:21. So literally this demonstrates to you a couple of things. How quickly a situation can change from second to second, minute to minute. They went from get there fast, back off. Get there faster because someone needs help. It's clear. The situation is dynamic and it's fluid. They're provided with information that an officer needs assistance. They testified about the sound of a struggle, right? And if you recall, Sergeant Steiger specifically said all of this information would be known to a reasonable police officer. And it goes into and factors into the reasonableness of the use of force. Ultimately, Officer Chauvin and Officer Tao arrive at Cup Foods. Just pause this for 1 second here. Sorry. When we look at Officer, I just have to give you a little piece of information. When we look at Officer Chang's video, Officer Chang arrives first. You see the time is 1:16:33 Z, Zulu. That's Greenwich Mean Time. Subtract 5 from 1 a.m., get you back to 8. So, Officer Chauvin and Officer Lane pull up. 8:16. Go over there.
Okay, just stay put, all right? I don't want anybody near his car.
Information gathering in terms of this assessment and reassessment of, again, the decision-making process of a police officer, right? Don't come over here where I am, Officer Chang says. Go over there. They need your help. Because what at that point, at that precise moment, they don't know what's happening over at the squad car. They don't know that Officers King and Lane struggled with Mr. Floyd, getting him out of the car, that they sat him down, that they stood him up, that they walked over. They haven't seen any of this information, and there's no evidence to suggest that they had. So that doesn't factor into the information. It's, again, a reasonable police officer. What do they know? And they don't know that. But they're starting to get some indication, hey, go over there, right? Go over there. You can see right at about 8:17, and I apologize for the quality of the picture, Officer Chauvin is arriving and walking up to the squad car. So what would a reasonable police officer see in this instance? What a reasonable police officer would see could be defined, because again, a reasonable police officer has to be aware of his department policies, active aggression or active resistance. Let's call it active resistance. A response to police efforts to bring a person into custody or control for detainment or arrest. A subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult for officers to achieve actual physical control. So as Derek Chauvin walks up to this scene, he has all of the information from dispatch. He has all of the information from Officer Chang sending him over. He knows his department policy on the difference between active aggression, active resistance, passive resistance, based on policy, training, etc. This is an officer's consideration of, again, the use of force. All of these things factor into it. So what does he see? He sees Officers King and Officers Lane struggling with Mr. Floyd, attempting to put him into the car. He hears the words that Mr. Floyd is saying at that point. I'm claustrophobic. I'm a good guy. I'm a good man. I'm claustrophobic. I just had COVID, right? He's hearing this information. He's observing with his eyes. A reasonable police officer is observing this with his eyes and his ears and assessing what he sees pursuant to policy. And what he sees, at a minimum, is active resistance. Mr. Floyd's not just simply getting in the back seat of the car. So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
You can't win.
I'm not trying to win.
Don't get in the car then.
I get on the ground, anything.
Don't get in the car.
He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man, please. Okay, can I talk to you, please?
So you get in the car, we can talk.
I am claustrophobic.
I'm claustrophobic, man. Working with me.
God, I'm claustrophobic right there, man.
Get in the car.
Get me in the front. Please.
No, you're not getting in the car.
I'm claustrophobic, Mr. Officer.
Get in the car.
Oh, yeah. Okay. I'm not a bad guy, man.
Get in the car.
I'm not a bad guy.
You ain't gonna win.
Oh, man. Oh, please, officer. Please. Please, man. Please.
Hold on a minute.
No.
You take the seat.
Hold
on a minute.
I can't choke. I can't breathe, officer. Please. Please.
Fine.
My wrist, man. My wrist, man, please. I can't take that, man.
By 8:18 and 15 seconds, Officer Chauvin has not laid a finger on Mr. Floyd, but he's observing. And a reasonable police officer is doing this. He walks onto a scene. He sees active resistance occurring, potentially active aggression occurring. He has two other officers. He has not intervened. But again, based on the policies and the training that you have seen, what were his options available to him at that time? If a person is actively resisting in the center, distraction techniques, controlled takedowns, conscious neck restraints. Can you clear that in? Right. These are options available to Mr. Chauvin at this point. He has, per his training, these techniques at his disposal. A reasonable police officer would be making these observations. He would observe the white foam around Mr. Floyd's mouth. He would consider the possibility that this person was under the influence of something. basically using the information from dispatch, making these observations. How is he analyzing this? How would a reasonable officer analyze this, and what would be known to a reasonable officer? A reasonable officer would look at the size of the person and assess that person's size in relation to his own size, because it's a part of the risk-threat analysis, right, that we've heard about so much. A reasonable officer would know that these are two rookies putting this man in the car. In fact, as the evidence established, Mr. Chauvin trained one of the officers. So a reasonable officer may step back at this point to see if these two guys can get this under control. A reasonable officer will hear the words that the suspect is saying. I'm a good guy, I'm a good guy, I'm a good guy, I'm claustrophobic. And he's going to compare those words to the actions of the individual, right? Because this is part of the analysis. Because I can say, I'm going to cooperate with you, I'm going to do whatever I want. But if my behavior is inconsistent with what I am saying, a reasonable officer takes that into consideration. In fact, a reasonable officer who's aware of his department policies knows the de-escalation policy that is in place. And part of what a reasonable officer has to do is to consider whether a subject's lack of compliance is a deliberate attempt to resist or an inability to comply based on these factors: medical conditions, mental impairment, developmental disability, physical language, language barrier, influence of drugs or alcohol, or behavioral crisis. So an officer, a reasonable officer, has to take the information and assess, is this suspect purposefully or intentionally, deliberately trying to thwart our efforts to take him into custody, or are they experiencing one of these other types of factors? But such consideration, when time and circumstances reasonably permit, shall then be balanced against the incident facts when deciding which tactical options are the most appropriate to resolve the situation safely. So again, a reasonable officer, based on the totality of these circumstances, is going to take all of this information in, all of these policies, all of these training ins, and a reasonable officer at that point would conclude that the amount of force that was being used by Officers King and Lane was insufficient. It was not enough use of force to overpower Mr. Floyd's resistance to getting into the car. He's seen it, he's heard it, he's familiar with the policies, and so at precisely 8:18 and 15 seconds, Officer Chauvin goes hands-on. Officer King, Officer Lane, and Officer Chauvin struggled, fought, whatever adjective you want to use. They struggled with Mr. Floyd from 8:18 till 8:19 and 12 seconds. About a minute, a little over a minute. It doesn't really seem that it's that long of a time, but again, the amount of physical exertion. Remember how Sergeant Jody Steiger described this. When the apparent attempts to get him into custody were futile. I wrote his quote down. The futility of their efforts became apparent. They weren't able to get him into the car. 3 Minneapolis police officers were not able to get Mr. Floyd into the car. They themselves are experiencing that surge of adrenaline. A reasonable police officer will be experiencing that surge of adrenaline. And again, balancing all of the evidence against each other, right? Let's look at 3 different angles of this struggle. This is Officer King's body camera.
Oh, I'm going down. I'm going down. I'm going down.
Get in the squad.
I'm going down. I'm going down. I'm not going to leave you.
Bro, you won't die of a heart attack, man.
I know it's green.
Get in the car.
I can't go, man. I can't breathe. I
Take a
can't
seat.
breathe. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I'll tell you.
Can we figure out what's going on?
For what?
Take him out.
For what? Please, man. I can't fucking breathe.
Hey, come on out.
Look at you. Thank you. Thank you.
Get him down the ground. Yeah, on the ground. On the ground.
My knees.
He's under arrest for forgery. Forgery for what? This is the video of the same time period from Officer Lane.
I'm on the ground. I'm on the ground. I'm on the ground.
Get in the squad.
I'm on the ground. I'm on the ground. Oh, I'm going down. I'm going down. I'm going down. I'm going down.
Squad.
I'm going down. I'm going down. I'm not going to breathe.
Bro, you won't die of a heart attack, shit, man. Get in the car.
I know I can't breathe. I can't breathe.
Talk to the brother. Take some oxygen, man.
I can't go, man. I can't breathe. I can't breathe. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
For what?
Take him out and just
For what?
MRE.
Please, man. I can't fucking breathe.
Hey, come on out.
Look at you. Thank you. Thank you.
Yeah, just when you get up there.
On the ground.
I appreciate that.
Officer Tao.
I'm on the ground. I'm on the ground. I'm on the ground. I'm going down. I'm going down. I'm going down. I'm not going to run, man. Right. I know I can't breathe. I can't breathe.
You're talking and oxygen. Breathe.
I just had COVID, man. I can't breathe. I can't.
He's going to jail? He's under arrest right now for forgery.
I can't.
Can we figure out what's going on?
What?
Take him out and just
For what? Please, man. I can't fucking breathe.
Hey, come on out.
Look at you. Thank you. Thank you.
yeah, just when you get up there.
On the ground.
I appreciate that.
A reasonable police officer understands the intensity of the struggle. You can see at points when Mr. Floyd's legs kick back, it actually almost knocks Officer Lane over. Right? It knocks off the body-worn camera and the badge of Officer Chauvin in this struggle. A reasonable police officer would understand this situation, that Mr. Floyd was able to overcome the efforts of 3 police officers while handcuffed with his legs and his body strength. A reasonable police officer standard can be seen in another way, from the milestone camera. And this is what caught the attention of the 911 dispatcher, Jenna Scurry. She said she observed the struggle and the vehicle rocking back and forth, back and forth. Watch the vehicle. reasonable police officers will consider their training, right? And before we talk about the training again, there's something that I think is really important to understand, two things actually at this moment. Not a single use of force expert that testified, not a single police officer who testified said that anything up until this point was unlawful or unreasonable. It was reasonable for these officers to put them into Mr. Floyd into the squad car. It was reasonable. The efforts that they took to overcome his resistance were reasonable. Every single expert agrees that to this point, nothing is contrary to policy, training, defensive tactics, crisis intervention, all reasonable. It's at the point that Mr. Floyd is brought to the ground that there becomes dispute about the reasonableness of the use of force and what a reasonable officer would know. It was Seth Stoughton, the law professor, who said at the point Mr. Floyd came out of the car, putting him on the ground was unreasonable. So, was it reasonable for Officer Chauvin or a reasonable police officer to put Mr. Floyd on the ground in that instance? So a reasonable police officer is going to rely on his training and information, his evidence, what he knows, all of the information he's built up to this point. You heard Lieutenant Mercil testify about how about 15 years ago the Minneapolis Police Department went to ground defense tactics, getting people on the ground to control them. Control the head, control the body. Different types of moves that the police use to create and eliminate space. Escape versus control. Those are two different things. These are the tactics that have been employed by the Minneapolis Police Department for 15 years. Why? Because it's safer for the officers and it's safer for the suspects. It keeps people contained, controlled, and confined until they no longer are resisting. A reasonable police officer would also consider his department's policies, including the use of non-deadly force policy. Force that does not have the reasonable likelihood of causing or creating a substantial risk of death or great bodily harm. This includes, but is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. This is the policy, 5-302 of the Minneapolis Police Department, that non-deadly force can be used to physically manage a person. And again, every single person has agreed that the use of force up to this point is reasonable, lawful, and meets the reasonable officer standard. And so we get into the 9 minutes and 29 seconds at this point. And the state has really focused on the 9 minutes and 29 seconds. 9 minutes, 29 seconds. 9 minutes, 29 seconds. It's not the proper analysis because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds. It completely disregards it. It says, in that moment, at that point, nothing else that happened before should be taken into consideration by a reasonable police officer. It tries to reframe the issue of what a reasonable police officer would do. A reasonable police officer would, in fact, take into consideration the previous 16 minutes and 59 seconds. Their experience with the subject, the struggle that they had, the comparison of the words to actions, it all comes into play. Why? Because human behavior is unpredictable. Human behavior is unpredictable, and nobody knows it better than a police officer. Someone can be compliant one second and fighting the next. Someone can be fighting and then compliant. Nobody knows it better. But reasonable police officers continue to assess and reevaluate. This is the critical decision-making policy, right, or model. You gather information, you assess the threat versus the risk. Do we have an authority to act? What are our goals and actions? Review and assess. Start over. Because this is not a singular cycle. This is a cycle that humans, as humans, we literally make millions of decisions in a day, right? Do I go this way? Do I go that way? Do I go up? Do I go down? I mean, we are constantly doing this. This is just human behavior. But in the policing context, you have to gather the information, assess the risk, assess the threat. Do I have authority to act? What are my goals and actions? Review and assess. And it's constantly rotating. At the precise moment that Mr. Floyd was laid on the ground, a reasonable police officer would know about those previous 17 minutes. A reasonable police officer would know about the struggle. A reasonable police officer would consider the suspect's reactions to the previous use of force. A reasonable police officer would continue this process of reassessment. And a reasonable police officer would consider whether to use an additional force to overcome the suspect's level of resistance, right? So 9 minutes and 29 seconds.
I appreciate that, I do.
You got your, Jesus Christ.
Thank you.
Stop moving. Mama.
Continuing to assess the risk and the threat. The first 29 seconds, 20 seconds, continued resistance is what a reasonable police officer would interpret that to be. Jesus Christ, the kicking. A reasonable police officer would consider, should we elevate the use of force as we meet this threat? And that's precisely what these officers did. They discussed using the MRT, the hobble.
Oh, please, man.
There you go.
Man, you're doing a lot of
Mama, I love you.
Are we calling for
I
EMS?
can't do nothing.
Yeah, EMS is on their way.
My face is gone.
Well, do you want to hop on at this point then?
I can't breathe, man. Please. Please let me stand. No. Please, man, I can't breathe.
They're discussing, should we use the hobble? Should we elevate our use of force? A reasonable officer would continue to evaluate whether the suspect is under the influence. Precisely what these officers did in this 9 minutes and 29 seconds.
The park's still sitting on the car there.
Look at my face, man.
I believe so. We found a pipe.
Wouldn't get out of the car.
I hate you, Mr. Real. Please,
Across the street, park's watching.
please,
Two other people with
please,
him.
I can't breathe. Please, man. Please.
A
Mama,
weed pipe on him, there might be
Mama,
something, so there might be like.
I can't. I'm bent.
Is that the
All right.
shaking of the eyes, right? Is PCP?
My knee, my neck,
Or their eyes like shaking
I'm
back and
through.
forth like that?
I'm through.
So reasonable police officers discuss the scene. The first clip, they're talking about the two other people that are over at the car, right? What's going on here? What are we dealing with? Is this person under the influence of a controlled substance? These are the actions of a reasonable police officer. A reasonable police officer would rely on his training and experience. Call EMS. Possibility that a suspect who was struggling with us will begin to struggle again. You've heard this testimony from multiple police officers. The risk that the suspect would present to himself if he's not continued to be controlled, and the risk that the suspect presents to other officers or citizens if not continued to be controlled, if he's not continued to be controlled, right? These are things that all of the police officers have testified about. These are what a reasonable police officer should do. A reasonable police officer in this situation would call EMS. 2020, 11, 8/20/11. Within a minute of the struggle, EMS code 2 for a mouth injury, right? Because they are not observing life-threatening, a reasonable officer is not observing life-threatening injuries at this point. They just fought with the man for a minute. He continued to kick at them when they got him on the ground. They see he's got a mouth injury. We need EMS. So a reasonable police officer would evaluate the injuries of the suspect, compare words and actions, and respond by calling EMS. Non-emergency. But again, reasonable police officers evaluate, reevaluate. 2021, 8/21, 1 minute and 24 seconds later. We need EMS here faster. Code 3. 3:30. We need him here faster. A reasonable police officer would take into consideration the anticipated time of a emergent response. You heard from Genevieve Hansen, there's a firehouse a few blocks away, and she would have expected EMS to be there within minutes. 3 minutes is what she said. A reasonable police officer, based on his training and experience, is going to have and take that into consideration. I put this person in a prone position on the ground. I'm holding them for my safety and their safety. I'm expecting someone to be here within 3 minutes to help this person. I have called for that help. A reasonable police officer will take into consideration, again, his training, his experience, right? Lieutenant Mercel talked about, and many people talked about, many of the officers talked about how it is not uncommon for suspects to feign or pretend to have a medical emergency to avoid being arrested. Unfortunately, that is the reality. Nobody likes to get arrested, and reasonable police officers know that. How many times does someone, oh, my heart hurts, or I'm having a medical emergency, insert whatever emergency, right? Simply because they don't want to go to jail. A reasonable police officer will take his training into experience. And you heard Lieutenant Mercel specifically say that when someone says that they can't breathe, but they are talking, if they're talking, it means they're breathing, right? If they're talking, it means they're breathing. And again, compare that to the testimony of Dr. Tobin, who told you that same thing. That is true. If you are talking, you are breathing. It doesn't mean effectively. And Dr. Tobin described how even medical doctors have problems sometimes assessing the legitimacy of a patient's needs relevant to their respiratory processes, because they're saying, I can't breathe, and some doctors confuse it for just anxiety or this or that. So if medical doctors make these mistakes, Dr. Tobin told you it provides a false sense of security, right? Lieutenant Mercel told you that that is what is said among police officers. He's the trainer. So how many times do we hear an officer say, based on his training and experience, if you can breathe, you can talk. If you can talk, you can breathe. Excuse me. I counted 7.
I can't choke. I can't breathe, buddy. Please.
You're talking.
Please.
Sit down.
Fine.
My wrist. I know I can't breathe. I can't breathe.
You're talking and not oxygen. Not breathe.
I'm sick.
Relax.
I can't breathe.
You're doing fine. You're talking fine.
I can't breathe. I can't breathe. Please. I can't breathe, officer.
You're talking. A lot of
They
yelling.
will kill me. They will kill me, man.
Takes a heck of a lot of oxygen to...
Come on, man.
Reasonable police officers, again, are trained and take into consideration a person's actions relevant to their words. Their training, their experience. Takes a lot of oxygen to talk. Takes a lot of oxygen. You're breathing fine if you can talk.
I can't breathe.
He's talking, so he's fine. Okay. We tried that for 10 minutes.
Bum ass shit, bro. That's some bum ass shit, bro. Y'all know that. You don't gotta sit there and show me on your neck, bro.
He's talking, he's fine.
Bro, he ain't
Okay. All right, we're done.
You circle.
Okay, we're
like,
done.
Reasonable police officers will take into consideration their training and experience on excited delirium, and they will analyze it within the context of this case.
on my side.
No, just stand where you got them.
I just worry about the delirium or whatever.
Let's try to get them.
Okay.
I worry about the excited or delirium or whatever. That's why we have EMS coming. It's not just leave them here. It's we have EMS coming, and this is why we have EMS coming. Reasonable police officers, throughout the course of a control technique, will continue to assess the level of resistance. And remember what Lieutenant Johnny Mercil said. Simply because a person isn't kicking at you or punching at you or biting at you, it does not mean that you can't control them physically with your body weight. This is at 8:24. This is the point where Dr. Tobin testified that Mr. Floyd had an anoxic seizure, right? But we're not analyzing the use of force from the perspective of a doctor with 46 years of medical experience who had 150 hours of time to watch an event from multiple perspectives over and over and over and over again. It's a reasonable police officer standard. How would a reasonable police officer interpret this? Does a reasonable police officer even know what an anoxic seizure is? A reasonable police officer will interpret this as at least some form of minimal resistance. Reasonable police officers, again, are continuing to monitor. They're expecting EMS to arrive.
No, but just how you knock it around. You're in that run right now. You get him off the ground, bro. You get him off the ground, you be in the run right now. He enjoying that. He enjoying that shit. He enjoying that shit. He a fucking bum, bro. He enjoying that shit right now, bro. You could have fucking put him in the car right now, bro. He's not convicted the rest of the shit. You enjoying it. Look at you. Your body language is crazy. Bro.
Non-deadly force is included. It includes, but it is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. These are the policies of the Minneapolis Police Department. Reasonable police officers, again, continue to monitor. See if he's breathing.
Yeah, I think he's passing out.
Assault at the police is available if you could start for an assault at next door to 2313 Washington Street.
All right, so,
Yeah, I mean,
not so far.
my knee might be a little scratched, but I'll survive.
I think he's passing out, but he's breathing, right? This anoxic seizure occurs. Reasonable police officers are building and basing their decisions based on all of these factors coming in at multiple times, including the bystanders, right? Call them a crowd, call them onlookers, call them bystanders. It doesn't matter what term you use for the people that gather to watch what police do. Reasonable police officers are cognizant of and aware of their surroundings. And before I really kind of start talking about the crowd in some limited detail, I have thought a lot during the course of this trial about the difference between perspective and perception. Perspective and perception are two distinct concepts. Perspective is the angle at which you see something. It's your perspective. Perception is how you interpret what it is that you see. I've thought about this a lot during the course of this trial because this situation here in the courtroom is incredibly unique, right? It's not the normal setup for a jury trial. So my perspective through the course of this trial, sitting in this chair, is that I cannot see 4 of the jurors. Very limited opportunity to observe the jurors. They probably can't see me either. Several of the jurors I have a very good view of. 4 of the jurors I don't, and obstructed views of others. My perspective sitting in this chair when witnesses, there's a camera blocking the head. So in order for me to see the witness, I have to roll all the way over to the other side. Then I have to look through the plexiglass that has these large reflecting lights. Right? Things block your perspective. Things can affect your perspective. But your perception is how you interpret what it is you see and what it is you experience. And that is our life, right? This is our experiences. These are the things that make us who we are. 3 people in this trial went to the same high school. Me, Darnella Frazier, and Chief Arredondo. We all went to the same high school, obviously at different times. My experience, Chief Arredondo's experience, Darnella Frazier's experience, all based on, we had the same perspective, sat in the same classrooms, saw the same chalkboards or whiteboards, the same perspective, but our perception of our experiences there is going to be much different. Ultimately, at the end of the case, when we're done with these arguments, the court will instruct you on how to deal with these biases and the perception issues. The court's final instructions will guide you to try to recognize your biases, recognize them, what we bring to the table, and analyze the evidence from the perspective of the evidence itself. So let's look at this incident on May 25th from the perspectives and perceptions of simply just 4 of the bystanders. Right? Charles McMillan, 61 years old, 3rd grade in education, grew up in the South. He described himself as a curious guy. He likes to know what's going on in his neighborhood, so he stops and he checks things out, right? his perspective, he's the first one who's dealing with these guys. He has more information because he sees the entirety of the situation. But his perception of the event is affected by his life's experiences. At the end of the night, ultimately what he said to Officer Chauvin was, I hope you get home safely, because that's what he says to police officers every night.
Can you advise the fire department if they're still with you, they need to go to 36th Park to assist with the feedback
But I
on
feel
school
respect
run?
you.
That's one person's opinion.
But no, I gotta get him in
We gotta control this guy because he's a sizable guy.
Yeah, and I tried to get in the car.
Looks like he's probably on something.
But I'm just saying, you know, but no, I got nothing bad to say about this, because you respect me, I'm gonna keep respecting you.
Right.
You have a good night, you go home safe in your family, don't keep you safe.
Darnella Frazier. She's a 17-year-old high school student who, upon seeing the restraint of George Floyd, her response was to pull out the cell phone and start recording, and then subsequently upload it to Facebook, right? Her perception of the event and her perspective of the event. She's looking, she didn't even know that Officers Lane and King were there because her perspective was blocked by the squad car. But her perception, her response to the situation was to record it, and that's perfectly fine. But she began her recording at 8:20 and 51 seconds. Donald Williams. He's a 33-year-old professional mixed martial artist who arrived at 8:22 and 39. He had spent the day fishing with his son, stopping for a drink when he became aware of the incident. He described his view of this based upon his perception as a mixed martial artist, right? He has a set of experiences that caused him to react in a different way. What he perceived was happening was that Mr. Floyd was being choked with a blood choke. I think we're past this at this point. The paramedic reached in, touched the carotid artery. To have a person rendered unconscious through a choke requires the blockage of both carotid arteries. This was not a neck restraint. This was not a chokehold. He was upset. And that, again, is okay because his perception affected what he was seeing. Genevieve Hansen, right? 27-year-old female firefighter for the city of Minneapolis. She testified that when she walked into the scene, she described the crowd as upset. She said, I walked into an upset crowd. She said that the other voices distracted me from getting the officer's attention. And she testified, again, based on her perspective, that Officer Chauvin appeared to have his hand in his pocket. She observed what she believed to be blood on the, from Mr. Floyd's face being pressed into the pavement. She observed fluid coming from Mr. Floyd's body that she presumed to be urine. She testified that nobody ever told her that EMS or an ambulance was on the way. She asked about, when I asked her about the response time she would have expected, 3 minutes. When I told her that paramedics had been called about 5 minutes prior to her arriving on scene, no way, because her perception is 3 minutes. But when you look at the things that Ms. Hansen saw, whether it be from her perspective or her perception, there can always be more to the story. The blood coming from Mr. Floyd's nose was why they called EMS in the first place. You've seen the pictures. He injured his nose during the struggle, or his face during the struggle in the squad car. The fluid that she described as potentially being urine, we know that that's fluid coming from the undercarriage of the squad car. Officer Chauvin specifically told her an ambulance was coming when she first came on scene?
Don't come over here. Don't come over here.
Off of the sidewalk. Yeah, we need you to keep some distance.
Yeah, the ambulance coming.
Yep, we got an ambulance coming. The computer-aided dispatch reports clearly show what time EMS was called. So Genevieve Hansen has a perspective and a perception. And what she observed was not consistent with the actual evidence. But remember, we don't look at this incident from the perspective of a bystander. We do not look at this incident from the perspective of the people who were upset by it. We look at it from the perspective of a reasonable police officer. A reasonable police officer, when confronted with these bystanders, would know everything that had occurred up to that point. 20 minutes, 25 minutes, 30 minutes. They know all of that information. The bystanders do not. A reasonable police officer would understand that his actions were actually being recorded. Take the bystanders out of it. Officers wear cameras for a very specific reason, to record their actions, so they know they're being recorded. Officers are aware of the placement of city cameras. You're in a high retail, you've got gas stations, restaurants, convenience store, high surveillance. Right? Reasonable police officers know this. They would know if citizens take out their cell phones and start filming. This is the point at 8:20 and 49 seconds when Miss Fraser starts recording. Reasonable police officers are aware when they're using force that sometimes what they are doing does not look good to the general public. A reasonable police officer will hear the frustration growing, right? A reasonable police officer will hear the increase in the volume of the voices. A reasonable police officer will hear the name calling, right? Chump, whatever names are being called. They'll hear the cursing. They'll hear this, and they'll take that into their consideration. A reasonable police officer will rely on his recent training. Excuse me. A reasonable police officer will hear I'll come back to the training. A reasonable police officer will hear what the crowd is saying. He will compare his actions to what they are saying, and he will determine, I know I'm being recorded, right? I know I'm being recorded. They're saying that I'm doing something that's awful looking. Am I doing this?
Right.
He is human, bro.
His nose is
What I'm saying, you can put him in the car. That's some
We
bum
tried
ass
that
shit.
for 10 minutes.
That's some bum ass shit, bro. That's some bum ass shit, bro. Y'all know that. You don't gotta sit there with your knee on his neck, bro.
He's talking, he's talking.
Bro, he ain't crying, bro.
Alright, we're done.
You circle like in a jiu-jitsu move, bro. You trapping his breathing right there, bro.
Okay.
Like, you don't think that what it is, bro? You don't think nobody understands that shit right there, bro? I trained at the academy, bro. That's some bullshit, bro. Right, that's bullshit, bro. That's bullshit, bro. You fucking stopping his breathing right there, bro.
Okay, he's talking. It's
He's
hard to talk when
talking.
you
Bro, but you
it's
can
hard
get
to
him
talk
off the
when
ground. You being a bum right now. You can get him off the ground, bro. You can get him off the ground. You being a bum right now. He enjoying that. He enjoying that shit. He enjoying that shit. He a fucking bum, bro. He enjoying that shit right now, bro. You could have fucking put him in the car by now, bro. He's not resisting arrest or nothing.
You can see Officer Chauvin's body language tells us a lot, right? That's what we just heard. Looking down, looking up, looking around, looking down, looking over, looking around. He's comparing a reasonable police officer. He's doing what a reasonable police officer would do. He's comparing his actions, his own actions, in response to what the crowd is saying. A reasonable police officer, again, will rely on his training. 2020, March of 2020, tactics of a crowd. Never underestimate a crowd's potential. Most crowds are compliant. Crowds are very dynamic creatures and can change rapidly. A crowd may contain elements of several types of groups. Now, I acknowledge that this is in dealing with massive crowds, protests and things of that nature. These are the tactics, but you never underestimate a crowd's potential because a reasonable police officer has to be aware and alert to his surroundings. A reasonable police officer will consider his department's policies on crisis. And what is defined as a crisis? Crisis. An event or situation where an individual's safety and health are threatened by behavioral challenges to include mental illness, developmental disabilities, substance abuse, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms and may include unusual stress in his or her life that renders him or her unable to function as he or she normally would. The crisis may not necessarily result in an upward trajectory or intensity culminating in thoughts or acts that are possibly dangerous to himself, herself, or others. Right? A reasonable police officer is recognizing that the crowd is in crisis. That all of these things, the members, the bystanders, the citizens, whatever you want to call them, they are in crisis. So a reasonable police officer considers his department's training. What are these potential signs of aggression that I may be confronted with? Somebody standing tall, somebody red in their face, raised voice, heavy breathing, tense muscles, pacing, right? This is from the crisis intervention training. This is what Kerr-Yang testified to. These are signs that police officers are trained to look for in a crisis as potential signs of aggression. How do you respond to those? You appear confident in your actions. You stay calm. You maintain space. You speak slowly and softly, and you avoid staring and eye contact. Again, these are things that Kerr-Yang discussed in terms of how to deal with a crisis. As this crowd grew more and more upset or deeper into crisis, a very critical thing happens at a very precise moment. And I cannot, in my opinion, understate the importance of this moment, the critical moment in this case. If you recall from Dr. Tobin's testimony, nobody disagreed, that Mr. Floyd took his last breath at 8:25:16. 8:25:16. What is happening at the very precise moment that Mr. Floyd takes his last breath? You're taking one piece of evidence and you're comparing it against the rest. This moment, 8:25:16, as Mr. Floyd is taking his last breath.
Get off of him now. What the fuck? He got mace. He got mace. He cannot breathe. Get over here. No, first of all.
Bro, look, well, you can check on him. He's not responsive right now.
Look at him.
He's not responsive right now. He's not responsive right now. He's not responsive.
Three things happen. Mr. Floyd takes his last breath. You see Officer Chauvin's reaction to the crowd is to pull his mace and shake it. He's threatening the use of force as is permitted by the Minneapolis Police Department policy. And Genevieve Hansen walks in at that time from behind him, startling him. All of these facts and circumstances simultaneously occur at a critical moment. And that changed Officer Chauvin's perception of what was happening. After this point, the crowd grows louder and louder, right? And at this point now, Mr. Floyd has taken his last breath, and the question is the rendering of medical aid. When do we stop CPR according to the Minneapolis Police Department's policy? When it's not safe. You heard Lieutenant Mercil talk about this, and you also heard Nicole McKenzie talk about this. Consider Nicole McKenzie's testimony. As far as the reasonable police officer, which would include Nicole McKenzie, she discussed at length the difficulty of performing CPR in what she would describe as, or she did describe as, a hostile environment. You miss signs. Agonal breathing can be confused for effective breathing. As she testified, people in the area can affect the decision to treat a subject at the scene. She described how it is incredibly difficult to perform EMS efforts in a loud crowd, difficult to focus when you don't feel safe, makes it more difficult to assess a patient, makes it more likely that you can miss signs that a patient is experiencing something. So the distraction, she said, can actually do harm to a patient. When we're talking about this critical decision-making model, right? As Lieutenant Mercil said, he testified, sometimes you have to take into consideration whether it is worth the risk to remove the handcuffs and render medical aid, because it's unpredictable, right? All of this information is coming at a reasonable officer. The reasonable police officer standard can also be extended to Officer Chang, right? What is his perception of the crowd? You heard him testify, but you can also look at what was he doing during this time?
Jawanda. What was that?
I think I'm gonna one of the store guys.
Okay, let's stay put. We'll figure it out, right?
Right? You've got Officer Chang pacing, turning around 360 degrees, right? His attention is focused on what's happening with the crowd. But he also has another job, right? Reasonable police officers and how they interact with the crowd is a consideration. You can also take into consideration the reactions of Shawanda Hill and Maurice Hall.
Damn, he still won't get in the car. Just sit down, dude. They gotta push him in this car. Look, he's fighting to get out. What is he doing? Now he going to jail. All he had to do was now the nigga going to jail. Look, they still fighting him. Hey. Oh man, what is he doing? Oh, they going all around.
Non-police officer and their reactions to what's happening. But also consider the paramedics, right? The paramedics. They did the load and go, right? As Derek Smith testified, he got out of the ambulance, he checked all four corners to gauge what was happening and determined, in his words, that it was an unwelcoming environment. And he told his partner they needed to move to a different location, a more safe and secure location. Remember Nicole McKenzie's testimony too. As unreasonable as it sounds, paramedics get attacked too. We have all of these different opinions in terms of the use of force, right? We have all of the opinions of Seth Stoughton, Jody Steiger, Barry Broad, Zimmerman, Arredondo, David Pluger, Lieutenant Mercel, and they all reach very different conclusions about when the force became unreasonable. All you have to know about Barry Broad is what he was talking about is this physically managing any person. His opinion was you can use non-deadly force to physically manage a person. It's all within the model of the MPD decision-making model. I found the most interesting person to be relevant to the use of force, Lieutenant Johnny Mercel, considering that he is Derek Chauvin's actual use of force trainer. So the best glimpse that we're going to get into the training of a Minneapolis police officer comes from the trainer who conducts the trainings. He's conducted hundreds of trainings over the years. He corrected the state at certain times in terms of how strike charts don't apply to restraint techniques. He said the knee on the neck is not an unauthorized move, and it can be utilized in certain circumstances. He described using a knee on the neck and back and stated that it can be there for an extended period of time, depending on the level of resistance you get. He said that once the suspect is handcuffed, it does not necessarily mean that it is time to move your leg, because when people are handcuffed, they can thrash around and continue to be dangerous to themselves and others. He talked about the ground defense program because it's safer for both the suspect and the officer. He talked about ground defense as a form of using your weight to control a subject without, and therefore replacing the need to punch or strike them. He said there's no strict techniques. You need to be fluid and adapt to the circumstances. That he personally trains officers to put a knee over the shoulder, up to the base of the neck, and he described this maneuver as routinely trained by the Minneapolis Police Department. He testified that there are circumstances that an officer would need to use his weight to continue to control a subject. He recognized the concept of awful but lawful, right? Sometimes the use of force is just not that attractive. He's experienced himself arresting people who have claimed to have a medical emergency. He explained how one way people can resist is through their words. He described how someone resisting can become passive and then become resistant again, and vice versa. He discussed how officers are trained not just to focus on the subject, but also the bystanders. He trains officers that if you're fighting with a suspect and that person then becomes compliant, it is a legitimate consideration for the continued use of force to control a subject. That if a subject overpowers more than one officer at a time, that is a legitimate consideration in the continuation of the use of force. He talked about substance abuse and how that officers are trained, right? I understand that superhuman strength is not a real phenomenon. I know there are no Supermen or Spider-Men, right? But officers are specifically trained that someone under the influence of certain types of controlled substances exhibit this behavior. They become stronger than they normally would. We've all heard the anecdotal stories of the pregnant mom lifting the car off of someone, right? It's not literally describing a superhero. It's simply describing that someone is exhibiting a greater strength. And the Minneapolis Police Department specifically trains that. He trains on neck restraints. Minneapolis Police Department has a specific written policy on the use of neck restraints, and it was permitted, even though this wasn't a neck restraint or a chokehold. He talked about how you need to cut off the blood supply for a neck restraint to both sides of the neck. He talked about how someone whose heart rate is beating faster, they go unconscious quicker, less than 10 seconds. He described the human factors of force. That is, how does the use of force affect the officer himself, his cognition, his abilities, his mental and physical state. He agreed that not using the MRT is a form of de-escalation. He described that sometimes you have to use your body weight to control a subject until the scene is code 4. He said that Minneapolis will train officers that under certain circumstances, an officer can hold a person in the prone position until the scene is safe. And he's done it himself at times. You have to take into consideration the presence of bystanders, where officers are located, and the environment that they're in. Lieutenant Mercil agreed that there are circumstances where I talked about this a little earlier ago, where you have to make a decision, is it worth the risk to take the handcuffs off to perform medical aid? He said there are circumstances where you wouldn't put someone in a recovery position, depending upon the safety of people, including the crowd, while awaiting EMS. He described how crowds can make situations chaotic. He said, simply because a person is not actively resisting, that does not mean that you cannot use force. Right? Doesn't mean that you cannot use force. Simply because someone isn't stabbing you, or punching you, or shooting at you, it doesn't mean that you can't use force. And that is specifically in the Minneapolis Police Department policy on the non-deadly use of force that we've looked at a couple of times. The use of force is an incredibly difficult analysis. You can't limit it to 9 minutes and 29 seconds. It started 17 minutes before that 9 minutes and 29 seconds. All of this information has to be taken, you have to look at it from the totality of the circumstances. You have to look at it from the reasonable police officer standard. You have to take into account that officers are human beings, capable of making mistakes in highly stressful situations. In this case, the totality of the circumstances that were known to a reasonable police officer in the precise moment the force was used demonstrates that this was an authorized use of force, as unattractive as it may be. And this is reasonable doubt. Steiger talked about being on the panel, right? They have 5 officers on a panel to assess whether uses of force are reasonable. Sometimes it's 4-1, sometimes it's 3-2, sometimes it's 5-0, because the reasonableness of the use of force is not an easy thing to consider. I know, again, I'm sorry, I'm long-winded. There are a couple of other things I need to talk about very briefly. I promise I'll be as brief as I can before I get to the cause of death. First is that concept of intent. As the state showed you, with respect to counts 1 and 2, you have to address Mr. Chauvin's intent. Pay careful attention again to the instructions. Words have meaning. Intentionally or intentional means that the defendant either has the purpose to do the thing or cause the result specified, or believes that the act, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal and that are set forth after the word intentionally, intentional. It's the same, you'll see a very similar instruction. You'll see this very similar instruction twice. Intent. Did Officer Chauvin intentionally apply unlawful force? That's what you're being asked to decide. did he purposefully apply unlawful force to another person? In count 2, you have to decide, did he purposely perform an act? Did he intentionally perform an act that was eminently dangerous? Right? What considerations do you have at your disposal? What pieces of evidence do you have? I'm going to try to go through these quickly. What evidence is there? What evidence is inconsistent with intent? Some facts and circumstances that are important for you to decide in terms of his intent is within the context of aiding and abetting other people. First, officers know that they are being videotaped. They know they're being videotaped by themselves. They know they're being videotaped by bystanders. They know they're being surveilled by the Minneapolis Police Department milestone camera, right? They know these things. Do you do something purposefully that you know is an unlawful use of force when you have 4 body-worn cameras immediately in the area, where you have multiple civilians videotaping you, where you know your actions are being reviewed through a city-owned camera, where there are surveillance cameras? Do people do things intentionally and purposefully when they know they're being watched? Remember, Officer Lane offered to have, when they were putting Mr. Floyd into the squad car, he said, I'll sit with you. I'll put the window down. I'll turn on the air conditioner.
Myself, man, please. I'm just claustrophobic. That's it.
Well, you're still going in the car.
Anything sharp on you?
I won't do nothing to hurt y'all.
Anything sharp?
No, sir.
Not even like a comb or nothing?
Nothing. I don't have nothing. Why y'all doing me like that, Mr. Officer? Please, crack it doing it for me and stuff, man. I am claustrophobic for real, Mr. Officer.
You got him?
Could you please crack it for me, please?
Yes, I'm
Remember my
cracking.
name. Stay with
I
me,
will.
man.
I will.
Please stay with me, man. Thank you. God, man. I didn't know all this was gonna happen, man. Please, man. I just want my hands, please. I don't want to do none of y'all, man. Nothing.
You got him?
Inside in his pocket real quick.
I'm listening. And I understand that people do stuff and
All right,
y'all
he's
know
good.
me.
That's what
Okay.
Grab a seat.
Okay. Having trouble watching because I was my
I'll roll the windows down, okay?
Please, man. Please don't do that.
Take a seat.
I'm going in, Mr. Officer. I'm going in.
you're not.
I gotta go in.
Take a seat.
Grab a seat, man.
Mind y'all don't believe me, Mr. Officer.
Take a seat.
I'm not that kind of guy. I'm not that kind of guy, man.
Take a seat.
Y'all, I'm gonna die here.
Take a
I'm
seat.
gonna die, man.
You need to take a seat right now.
And I just had COVID, man. I don't want to go to that.
Okay, I'll roll the windows
No.
down. Hey, listen.
Dang, man.
Listen.
I'm not that kind of guy.
I'll roll the windows down
Please,
and put
man.
your legs in, all right? I'll
Y'all
put the air on.
stop. Look at that. Look at that.
Not even listening.
Look at it. Look at it.
All right. I'll roll the window down 3 times. I'll turn on the air conditioning. Is that evidence of intent to apply unlawful force? Officer Chauvin confirms that Mr. Floyd is under arrest.
Take a seat. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
For what?
Take him out.
For what? Please, man.
Officer Chauvin made a decision not to use higher levels of force when he would have been authorized to do that, including punches, kicks, elbows, right? All of these tools were available to Officer Chauvin. That is not an intent to purposefully use unlawful force. They call for EMS within 1 minute of putting him on the ground. They step it up within another minute and a half. He believes that Officer Chauvin believes that Mr. Floyd's ability to speak means he can breathe, and they say it repeatedly, remember? Excuse me. They tell him to relax.
You're the arrest guy.
All right. Oh, my God.
So you go to
I
jail.
can't believe this.
Officer Chauvin is never swearing at him. He's not calling him names. All of this stuff that we've already talked about, and I don't need to go through this again. All of this stuff that we've talked about throughout the entirety of this circumstance does not reflect an intent to purposefully, intentionally commit an unlawful use of force. All of the evidence shows that Mr. Chauvin thought he was following his training. He was in fact following his training. He was following Minneapolis Police Department policies. He was trained this way. It all demonstrates a lack of intent. There is absolutely no evidence that Officer Chauvin intentionally, purposefully applied unlawful force. Officer Chauvin is also refocusing the other officers, telling them they need to do things to pay attention to Mr. Floyd.
You are to acknowledge person tonight.
Let's get him on.
Should I put his stuff in the car? No, we need to get him in the ambulance. Let's refocus, right? Officer Chauvin had no intent to purposefully use, or he did not purposefully use unlawful force. These are officers doing their job in a highly stressful situation. According to their training, according to the policies of the Minneapolis Police Department, and it's tragic. It's tragic. They go to the hospital. They perform CPR. They call their supervisors. Was this an eminently dangerous act? Was putting Mr. Floyd an eminently dangerous act? We've heard a lot about the prone position. Consider just the basic prone position. People sleep in the prone position. People suntan in the prone position. People get massages in the prone position. The prone position in and of itself is not an inherently dangerous act. It is not an inherently dangerous act. A prone position during restraint is not an inherently dangerous act. It is routinely trained and used by the Minneapolis Police Department. The studies show, right? The Canadian studies that were referenced by Dr. Fowler. 1,269 cases, use of force, one death of a person not in the prone position. Right? These are people, they're looking at people in the prone position. 4,828 consecutive force events. No significant clinical effects on the subject's physiology. Right? We can look at all of the other studies trying to determine this question is putting a subject in the prone position, even with officers on top, even with weight on top of the person, is that inherently dangerous? And the research says no. The practical experience says says no. The prone position, when applied through a use of force, is not an eminently dangerous act because there is no evidence to support the notion that it was highly likely, that's the standard, highly likely to cause death. There's reasonable doubt about that. So let's talk about the cause of death. And again, I'm sorry to be long-winded, but I have to address the cause of death. Because the state neglected to read perhaps one of the most important sentences from the instruction, and why you must read the instruction carefully. Yes, the defendant is criminally liable for all of the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes. If such intervening causes were the natural result of the defendant's act. Okay? So if the intervening causes were the natural consequences of the defendant's acts, he's liable. So think about it in this example. Police officer arrests somebody. He puts that person on a hot August afternoon in the back seat of a squad car, rolls up the window, turns on the heat, and leaves the person in there, right? Person dies of a heat stroke. Officer put him in there and is responsible for the natural consequences of his actions. But consider the situation where police officer arrests someone, they're compliant, they go into the back seat of the squad car, they're sitting in the back seat of the squad car, and they have a heart attack. They have a pulmonary embolism. They have a brain aneurysm. Something happens to that person that was not the natural consequence of being arrested. It was just a physiological something that happened to that individual. The officer is not liable because it's not in the natural course of events. And it's not the result, the natural result of the defendant's act. Right? So again, read the entire instruction. The significance of this instruction, again, is that it goes through all of the three charges. You have to be convinced that the defendant's actions caused the death of Mr. Floyd. And throughout the course of this trial, the state has tried and called numerous witnesses to try to convince you that asphyxiation is the singular cause of death. The singular cause of death. And why is that? It's because actions that happened before Mr. Floyd was arrested that had nothing to do with Officer Chauvin's activities are not the natural consequences of the defendant's actions. You have to focus on the consequence of the defendant's acts. And so the state has tried to convince you beyond a reasonable doubt that the stress of being arrested and the adrenaline produced as a result of Mr. Floyd's physical resistance played no role. This is what they have to try to convince you. There's no role of that physical exertion. Played no role in this death. They're trying to convince you beyond a reasonable doubt that Mr. Floyd's heart disease played no role in this case. The state must try to convince you beyond a reasonable doubt that Mr. Floyd's history of hypertension played absolutely no role in the cause of Mr. Floyd's death. The state must convince you beyond a reasonable doubt that Mr. Floyd was not experiencing excited delirium that contributed to the cause of his death. The state has to convince you beyond a reasonable doubt that Mr. Floyd's paraganglioma was not contributing to the cause of death. The state must convince you beyond a reasonable doubt that Mr. Floyd's toxicology played no role in his death. Right? The state would have to convince you beyond a reasonable doubt that a combination of these pre-existing issues did not contribute to Mr. Floyd's death. That is why the state has brought in expert after expert after expert to testify that the singular cause of death here is asphyxiation. Because if Mr. Floyd was asphyxiated as a result of the police restraint, he is liable for the natural consequences of that restraint, of his actions. But if any of these other factors come into it, if any of these other factors were substantial contributing factors of Mr. Floyd's death, because they were not the natural result of the restraint, If a person has drugs in their system and that drug causes an overdose, in the context of the police restraint, it's not the natural consequence of the restraint, it's the natural consequence of the deceased's actions. So the state has called 6 experts, really 5, but I'll include Dr. Baker. The state first called Dr. Tobin, a pulmonologist. Dr. Tobin said that you need to apply common sense to the evaluation of the medical testimony. He testified that Mr. Floyd died exclusively from positional asphyxia, coronary artery disease, hypertension, controlled substances. They played absolutely no role in the death, according to Dr. Tobin. The state called Dr. Eisenschmidt, a toxicologist, to explain to you that Mr. Floyd's toxicological levels were somehow more consistent with a DWI case than a whole bunch of other cases that may or may not have involved an overdose, right? Remember the ratio where you said, well, no, these are cases, they may have died of something else. They may have died of a gunshot wound, but they had fentanyl in their system. So he gave you these strange statistics, but essentially attempting to try to convince you that these levels are insignificant. People drive their cars around, right? And that therefore the drugs played no role in the death of Mr. Floyd. Third, the state called Dr. Smock, an emergency room physician, right, to explain to you that Mr. Floyd was not experiencing any symptoms of excited delirium. And that coronary artery disease, hypertension, controlled substances, none of that comes into play. They called Dr. Thomas, a pathologist, to testify how she interpreted what Dr. Baker meant. How she concluded that Dr. Baker simply said that the cardiopulmonary arrest is the basic way everybody dies. And she interpreted the reason why Dr. Baker put those factors on his autopsy or on the death certificate were merely for statistical purposes. You put stuff, the CDC requires us to put that stuff on there. And it was an asphyxial death. Controlled substances played no role. Hypertension played no role. Coronary artery disease played no role. They did call Dr. Baker. And we'll talk about Dr. Baker in a minute. And finally, the state called Dr. Rich, a cardiologist who concluded that despite a 90% narrowing of the right coronary artery and a 75% narrowing in the left anterior descending artery, despite an enlarged heart and a history of hypertension, that Mr. Floyd had a strong heart, and that none of those pre-existing and coexisting conditions in any way contributed to the death of Mr. Floyd. I submit to you that the testimonies of Dr. Tobin, Eisenschmidt, Schmock, Thomas, and Rich, it flies in the absolute face of reason and common sense. It's astounding, especially when you consider the actual findings of Dr. Baker, right? Because Dr. Baker is the only person who actually performed the autopsy in this case. He's the only person who performed the actual autopsy. He told you that he specifically avoided watching the video because he didn't want to bias or influence his autopsy. He specifically testified that there was no evidence of asphyxia. There were no evidence of petechial hemorrhaging. There was no bruising to the neck or back above the skin, under the skin, or into the subcutaneous muscles of the neck and back. And he would expect to see those things in a case like this. There was no finding that pressure was applied to the point of Mr. Back to cause these injuries. There were no injuries to the structures of his neck, and that when he finally did review the video, it didn't appear that the placement of the knee affected the structures of the neck because Mr. Floyd could lift up his head, turn his head, move it around. He saw no fractures to the structures of the neck, including the hyoid bone. There were no soft tissue injuries to the sides of Mr. Floyd's neck. There was no hemorrhaging or injury to the hypopharynx. No evidence of life-threatening injury to the neck or spinal column of Mr. Floyd. There was pulmonary edema, which is the swelling of the lungs, which could be caused by the resuscitative efforts or fentanyl. There's no evidence of hypoxic changes to the brain. There's no evidence of any brain injury consistent with an asphyxia death. He found a paraganglioma, and he said it was an incidental finding. He said his heart was enlarged. Mr. Floyd's heart was enlarged, right? Dr. Baker, Dr. Thomas, Dr. Rich, and Dr. Fowler all agreed. He found narrowing of the right coronary artery, 90% narrowing. He found 75% narrowing of the left anterior descending artery. He's the person who did he sent out the toxicology samples. Fentanyl level at 11 nanograms per milliliter. Methamphetamine at 0.19 per millimeter. All of these findings that are ultimately relied upon by all of these other experts were done by Dr. Baker. He determined that the manner of death was a homicide, right? Homicide, homicide, homicide. But read the definition again of the medical definition of homicide. It is to be emphasized that the classification of homicide for the purposes of the death certificate is a neutral term and neither indicates nor implies criminal intent, which remains a determination within the province of the legal processes. Right? The fact that he found this a homicide is a medical term. Dr. Fowler talked about the undetermined manner. Could not be determined is a classification used when the information pointing to one manner of death is no more compelling than one or more other competing manners of death in or through consideration of all available information. Dr. Baker found the immediate cause of death and the other contributing factors. Cardiopulmonary arrest complicating law enforcement, subdual, neck restraint, and neck compression. Other contributing factors are arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The term complicated in this is important because Dr. Baker was able to give you what he said his actual intent was, right? Dr. Thomas speculated about what she thought Dr. Baker meant. Dr. Baker was able to tell you what he meant. He defined complicating as an intervention that occurred and there was an untoward outcome on the heels of that intervention. And he gave you a specific example. He described a person having a hip surgery and a blood clot comes loose and that blood clot causes a death. The hip surgery didn't cause the death. The death was caused by the blood clot that complicated the surgery. So as I understand his testimony, what Dr. Baker was saying was that there was an unexpected result. The death of Mr. Floyd occurred during an event where you would not generally expect such a complication, subdual and restraint. He specifically testified, Dr. Baker specifically testified that if he put it on the death certificate, it played a role in the death. If something is insignificant to death, you don't put it on the death certificate. So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death of Mr. Floyd. Dr. Baker concluded that Mr. Floyd's fentanyl intoxication played a role. Dr. Baker concluded that Mr. Floyd's recent methamphetamine use played a role. Right? Dr. Baker described that this death of Mr. Floyd was a multifactorial process. A multifactorial process is how he defined it. No single factor, one over the other, played any more of a role resulting in Mr. Floyd's death. He said his heart simply couldn't handle it within the context of the subdual and restraint. Apparently, the state, as they just argued, wants you to believe what you see. And they did not like Dr. Baker's conclusions. And you can see the process Dr. Baker talked about when he had several meetings, right? This happened in March. Excuse me, happened in May, June, July. By August, talk to a pulmonologist, talk to an emergency room doctor, not within my area of expertise, talk to a cardiologist, right? His findings didn't support the notion that what you see is what you should believe. And so the state did that. They went and hired Dr. Tobin, right? A pulmonologist. Now, despite all of the information that Dr. Baker has concluded or found during the actual autopsy, Dr. Tobin concluded emphatically that Mr. Floyd's death was the result of positional asphyxia, right? The pressure of the asphalt, pressure of the weight of the officers, the positions, all of this resulted in hypoxia, low oxygen to the brain. Mr. Floyd was asphyxiated through positional asphyxia. Remember at the beginning of my remarks, I asked you to perform an honest assessment of all of the evidence in the case. And I'm going to submit to you that with no other witness should this be more carefully analyzed. I want to illustrate two brief things that Dr. Tobin testified about, and I want to illustrate how I think that these demonstrate a bias, because you still have to consider an expert witness in the context of bias. I'm going to call it the finger and knuckle testimony and the toe lifting testimony. You may remember this slide, right? That this slide shows George Floyd pushing his fingers against the street to lift his shoulder off the street. That he was pushing his knuckles against the tire. Right? He described what he interpreted this was basically Mr. Floyd trying to push himself up onto his left side to free the right lung to help him breathe. Look at the timestamp of the photos taken from the body-worn camera here. They were taken at 8:19:35, 15 seconds after Mr. Floyd was placed on the ground. Yet Dr. Tobin also explained that Mr. Floyd went on to breathe for an additional 5 minutes and 51 seconds until he took his last breath at 8:25. He neglects the fact that at this point, this is the point that we just saw, when Mr. Floyd is taken out of the car and he is actually in the side recovery position for about the first 2 minutes of this 9 minutes and 29 seconds.
Not moving.
Mama! Mama!
Yeah,
Mama! Mama!
One of the front couches
Mama!
on my right side bag.
Mama! Mama!
You're the best guy.
All right. All right. Oh my God.
It's not going to
I
jail.
can't believe this. I can't believe this. I can't believe this. I can't believe this, man. Mama, I love you. Reese, I love you.
got hobble?
Just by getting a level. I'm
Mine
dead.
is my side, it's listed, it's labeled. It says hobble. It's on the
I can't
top.
breathe for nothing, man. It's cold blooded, man. Ah, ah,
And you're doing a lot of
Mama, I love you. I can't do nothing.
Yeah, EMS is on their way.
My face is gone. I can't breathe, man. Please. Please let me stay in.
No.
Please, man, I can't breathe.
Get up on the sidewalk, please, one side or the other,
My face getting bad.
please. Here, should we get his legs up?
Oh my God.
Nope, just leave them.
Oh
Just
my
leave them.
God.
Just leave them. Yep, just leave them.
All right.
I'm dead.
The park's still sitting on the car.
Whoa.
They were-
Look at my face, man.
How can you take, this illustrates how you can take a single nanosecond of time in this arrest. You can have this testimony that he's pushing his body up to try to breathe, right? But when you look at the evidence compared to the rest of the evidence, what do you really see? You see a person who is on his side, being held in the side recovery position, whose hand is touching the ground and the tire at times. You cannot take a single isolated frame and reach any conclusions because much like the use of force, the cause of death has to be considered within the totality of the circumstances. And then you remember this testimony. This is Officer Chauvin's foot off the ground. And he described how at this precise moment, Officer Chauvin was applying 91.5 pounds of pressure to the neck of Mr. Floyd. So let's look at this time in the context of the other evidence.
His whole nose is
Fought with him.
Why you just sitting there? He ain't doing nothing now. Put him in the car.
Don't kill me.
How long y'all gotta hold him down?
This is why we don't do drugs, kids. It ain't about drugs, bro. You understand that?
Did anybody even see the toe come up off the ground? I mean, was it a half a second, a quarter of a second? Right? But when you take a single incident, a frame, a single frame, and you add the drama, and you make all of the assumptions, right? Officer Chauvin's body weight, Mr. Floyd's EELV. He's the only person who calculated the EELV based upon the presumptions of health, based upon studies, based upon theory. All of this information, you can put this into a single frame, but you have to analyze the evidence in the broader context. You can also see during the clip that Officer Chauvin actually is sort of adjusted forward and touches this car, right? You can make a lot of informed decisions about how is he shifted. If I'm shifting my weight this way, majority of my weight is shifting on my left foot. If I'm this way, it's on my right foot. You watch this video and you can see the dynamic shifting. And you can see the placement of the toes, right? The toe tucked under helps an officer maintain his weight, or helps any person maintain their weight. But a toe flopped over to the side, it's a little harder to balance. You cannot take a single frame and draw conclusions. You have to look at the totality. And remember, he said he spent 150 hours analyzing this tape. His entire testimony is filled with theory, speculation, assumption. Do not let yourselves be misled by a single still frame image. Put the evidence in its proper context. We have to talk about the toxicology. Again, we're not suggesting that this was an overdose death, right? It's a multifactorial process, as Dr. Baker said. So we have to look at what role does the toxicology play in this case. And you need, because again, we had Dr. Eisenschmidt who testified that he found that the levels of fentanyl and methamphetamine were more consistent with this DUI population. But what do we know about the actual toxicology? There were 11 nanograms per milliliter of fentanyl and 0.19 nanograms of methamphetamine. Those are the principal two findings. And additionally, what we know is that the byproduct of methamphetamine, which is amphetamine, was not reported at the levels. Doesn't mean it wasn't technically there, but it was not reported. So it's below threshold reporting values, which signifies that the methamphetamine use was recent. Hence, in Dr. Baker's death certificate, he included the recent methamphetamine use because there was no amphetamine. The history of Mr. Floyd's use of controlled substances, it is significant. It's not a character problem. Millions of Americans suffer from the opioid crisis, right? I mean, it is a true crisis that this country is facing. But it is significant to understand the history, not just as much as the long-term history, but his long-term history provides us with insight on how his body physically reacts to methamphetamine or opioid use, I should say, opioid use within the context of a law enforcement encounter. We know from the testimony of Courtney Ross that Mr. Floyd struggled. We know he had been using controlled substances habitually for some time. We know that on May 6th of 2019, during an encounter with the police, Mr. Floyd ingested some controlled substances, said they were Percocets. He was startled by the police, like he was in this case. Officer drew his gun in that case too. And that resulted in a blood pressure of 216/160. I mean, that's not just high. That is skyrocketing high. We know from Ms. Ross that in March of 2020, they purchased some pills that were supposed to be Percocets, an opioid. But they were clearly knockoffs. She described that. They were clearly knockoffs. She described how those pills made her feel. They kept her up all night, right? The introduction of the methamphetamine. We know from Ms. Ross that in March of 2020, Mr. Floyd was seen for a drug overdose. She described how he felt in that instance. She said his whole body hurt. His stomach hurt. We know, based on, again, from Ms. Ross, that he was clean and sober for some time while they were in quarantine. We know that Ms. Ross again described taking about a week before a similar pill to the one that they had back in March. Kept her up again all night, right? She said she felt like she was going to die. We know, again, from Ms. Ross, that those pills were purchased from Maurice Hall. She described going to a hotel. While Mr. Floyd went into the hotel, she was on the phone with him. She heard Maurice Hall's voice. We know Mr. Floyd was with Maurice Hall on May 25th, 2020. We heard from the store clerk, Christopher Martin. He described Mr. Floyd as being high. His responses were delayed, right? He may have been, standing around. He may have been standing up. He may have been able to have communications. But Mr. Martin clearly described him as being high. We heard from Shawanda Hill that when they got back into the car, right, they had a conversation for a few minutes, and suddenly Mr. Floyd fell asleep. All of these things become important. That had trouble. They had trouble waking him up. She called her daughter for a ride because they couldn't wake Mr. Floyd up. They couldn't keep him awake. We heard how Mr. Martin described Mr. Floyd when he went back to the car and how he was, oh no, he wasn't speaking, right? But he kept putting his head back and shaking his head. We know from Peter Chang's body-worn camera that Maurice Hall also described that Mr. Floyd was dozing off.
He got because he was falling asleep a little bit, and then when he woke up, they was up at the door.
Right? We know that whether Mr. Floyd was chewing gum while he was in the store, we can also see he was eating a banana. Right? He bought a banana. So we know when we look at this picture, right, there's something in Mr. Floyd's mouth. Is it gum? Is it banana? Is it drugs? Nobody knows, right? But regardless of whether it's drugs, bananas, or gum in this incident, we know that there were pills in the car, right? We know that there were drugs in the car. We know those pills were later tested to be a combination of methamphetamine and fentanyl. That's what was in Mr. Floyd's system. It's relevant because it's what was in his system. These are the pills that were found. We know at some point Mr. Floyd was handcuffed. His hands were behind his back. It would have been physically impossible to put anything in his mouth at that point. And we know that in the squad car, 320 were pills. We know those pills were analyzed. We know those pills consisted of fentanyl and methamphetamine. We know that Mr. Floyd's salivary DNA was found on those pills. How much fentanyl does it take to kill? This is from the Minneapolis Police Department's training. Approximately 2 to 3 milligrams. Smaller than a penny. This is from the squad car. You can look at these pictures closely during the course of your evidence. There is a video of Mr. Floyd when Mr. Floyd is being subdued by and restrained by the police. Mr. Maurice Hall reaches into his bag. He's looking through the windows. We watch it. And then he throws something. Right? We know that Mr. Floyd had drugs in his mouth. We know that some percentage of that would have been consumed and absorbed into his system. We don't know how much he took before. Right? We don't know when he took an earlier dose in relation, because fentanyl had actually started to metabolize in his, so fentanyl was longer before. for the medical experts to minimize the timing and the amount of illicit drugs that were found in Mr. Floyd's bloodstream, it is just simply incredible to me. It is incredible to me. Every single doctor testified that relevant to that the absence of signs of fentanyl overdose weren't present because he was alert, he was talking. But it ignores what Shawanda Hill and Maurice Hall says, right? That he was all of a sudden asleep and difficult to wake up. It ignores the fact that the combination of these two drugs, methamphetamine is a powerful stimulant. Fentanyl is a powerful sedative. They use it for surgeries. Every single doctor dismissed outright. No, nothing about this case. Well, it was only 0.19 grams, nanograms per milliliter. It's such a small amount of methamphetamine in his system. It's a vasoconstrictor. It causes the heart's arteries to constrict even tighter. Doesn't matter. Every single doctor just brushed it aside, said it would have no effect. I ask, would any of those doctors prescribe illicit methamphetamine to their patients? Would they give it to their children? Would they give it to their elderly parents with a 90% blockage of the coronary artery, the right coronary artery? I guarantee you the answer is no. Dr. Rich is the only one who said, I would never recommend to my patients that they take any amount of illicit methamphetamine. It is preposterous that it is a preposterous notion that this did not come into play here.
Half-hour break for lunch. I don't want to interrupt your argument, but
Thank you. I apologize.
members of the jury, 30 minutes for lunch, please. Thank you.